Hello, viewers! Tonight we're diving into the thrilling world of international arbitration law. Just kidding, it's way more boring than that. But it does involve something we all love: loopholes. Specifically, what happens when an arbitration agreement forgets to mention where the arbitration should actually happen. This isn't about choosing between Pizza Rat Sewer and Times Square for your dispute resolution. It's about which court gets to decide who gets screwed. Enter Section 11, Subsection 6 of India's Arbitration and Conciliation Act, 1996. This little gem comes into play when an arbitration agreement exists, but nobody bothered to specify the seat or venue. Think of it like this. You agree to settle your differences in a boxing ring, but forget to mention which boxing ring. Madison Square Garden, some guy's basement. Without a location, you've just got an agreement to punch each other somewhere. Section 11, Subsection 6 steps in to say, fine, we'll find a referee, but we need to figure out which court gets to send one. And that's where things get messy. So, how does a court decide it gets to play referee in this jurisdictional free-for-all? They turn to the Civil Procedure Code, or CPC, for clues. Specifically, Sections 16 to 20, which are basically the Sherlock Holmes of legal codes. These sections look for hints like, where was the contract signed? Where did the alleged shenanigans go down? Where does the defendant hang their hat? Or more formally, conduct business? It's all about connecting the dots and finding the court with the strongest link to the case. Think of it like a game of Clue. Was it Colonel Mustard in the library with the candlestick? Or was it Mr. Green on the internet with a poorly worded contract? The CPC sections are like those little detective notepad pages helping the court eliminate suspects, or in this case, jurisdictions. Now let's look at a real-life example of this jurisdictional puzzle, because nothing says riveting television like legal precedents. In the recent case of 2025, the Delhi High Court was tasked with untangling a jurisdictional mess. The agreement? Silent on the seat and venue. The plaintiff's argument for jurisdiction in Delhi? The defendant had a bank account there. The court's response? Nice try. But that's about as convincing as saying you live in a pizza place because you get delivery there once a week. The court ultimately ruled that the case had stronger ties to Odisha, where the construction project, the defendant's primary business, and most of the relevant events took place. Delhi, with its solitary bank account, just didn't make the cut. This case, along with others like 2025, highlights the importance of specificity in contracts. It's like asking for directions and just getting a shrug emoji in response. Not helpful. So, what's the takeaway from all this legal jargon? Simple: be specific. When drafting arbitration agreements, don't leave the seat or venue up for interpretation. It's like forgetting to put a return address on a strongly worded letter. You might feel better in the moment, but it won't end well. Remember, the goal of arbitration is to resolve disputes efficiently and fairly. Spending months arguing about which court gets to hear your case just adds time and expense, defeating the whole purpose. So, do yourselves a favor and make your agreements crystal clear. Otherwise, you might end up on an episode of this show, and trust me, nobody wants that.